those of you, welcome
Sorry.
those of you who were in Teams land to our Zoom meeting. Glad to have you here. And we have a number of guests today. I want to make sure to get them introduced because really I think the focus of this meeting is going to be some conversation around some questions that were presented by a couple of our work group members that really reflected conversation over the last couple of meetings. And I would say those questions generally revolve around security of the document of the will, and then to a lesser extent, just maybe sort of the administrative processing of an electronic will by the court and how that gets done. Those questions were distributed to the group. I hope you have them. I printed them for myself, so they're ready and available. But we don't necessarily need to go through the exact questions, but I think they have set the general scope of inquiry. And Jeff and Matt, if you, I think you were the two who put the questions in. If you want to make sure that a couple of them get answered specifically, we'll be sure to take the time to do that. But let me introduce, I think, our guests here, and I may miss some, so I'll ask for forgiveness for that up front. And if I do miss one of our guests, please speak up. We have with us Judge Diana Kiesel. Is that about how you pronounce your last name, Judge?
Yes, Kiesel is Diesel with a K.
Okay, very good. And let me just say, Judge Kiesel is with us from Clark County in Washington. And she had tongue surgery yesterday, and so will be speaking, but not a lot today. As she says, it hurts to speak. Amanda, Andrea, are you with us? Don't see Andrea. Okay, Amy is saying no. Ben Orzeski. Ben, hi Ben. Those of you who have worked on other Uniform Law Commission work groups will know or recognize Ben. Ben is with the Uniform Law Commission in Chicago. Ben, do you want to just introduce yourself real quickly?
Sure. Thanks for having me. I'm responsible for uniform acts in the trust and estate world as well as the UCC, and happy to consult with this group as you're considering the UWills Act. Thanks.
All right, thanks. And Susan Gary, Professor Gary, good to see you, Susan. Susan, you're retired, right?
I am.
Yeah, retired law professor from the University of Oregon, and auspiciously was the reporter for the Uniform Electronic Wills Act at the ULC. So, Susan, anything else you want to say just by way of introduction? You've done a lot of work with the ULC over the years.
I have, and the questions that were raised are all the same questions that we talked about on the drafting committee. So I'm happy to share our thoughts and kind of how we landed on some of the decisions we ended up making.
Okay, great. Is there anybody else with us that is a guest for the conversation today? I do want to welcome
I'm a guest.
Lauren, sorry, please.
Hi, I'm a law student at Willamette Law, and my professor Cook is on this call, and I'm just chiming in because I'm working on my graduation writing requirement on this topic. So she invited me graciously. I'm excited to hear.
Well, great, very good, very glad to have you, Lauren. And not a guest, but I want to make sure to introduce Victoria Blatchley. Victoria, you've gone off camera. There you are, two hands up. Victoria is, I ate mine before we started. Victoria, and I'll give you just a second here while you're swallowing, but Victoria is a Uniform Law Commissioner from Oregon, and actually served with Susan on the drafting committee for the Uniform Electronic Wills Act. So Victoria was party to those conversations as well, and she's a member of this work group as well. But I think maybe you weren't here at the last meeting, Victoria, so I wanted to make sure that people who don't know you had a chance. We just want to say a couple of words of introduction.
My Indian food is delightful, so that's really where I'm primarily focused right now. You are in good hands with Professor Gary. She is the bee's knees, and she will guide us all towards the light.
Okay, It looks like you're in your office today.
I am in
Anybody else in Big Pink today, or are you the only one?
4 or 5 of us in the building. It's quiet.
Oh, that's so sad. All right. Well, we have a couple of perspectives here. One is we did invite Judge Kiesel to meet with us about the Washington experience. I know that you were sent the link to the Washington State Bar News article. It was a really good report on the Washington enactment, including the non-uniform provision for the maintenance of electronic wills by a will custodian. And Judge Kiesel, I followed your emails, and thank you for the time that you spent on this in the last week or two getting ready for this. I'll try and save you some speaking, but I'll start with your experience. My understanding from what you've gleaned is that really the experience has been kind of nil in Washington in terms of probate of electronic wills. And I guess is my understanding right of the emails that I've seen back and forth?
Yes.
Oops, you just went mute.
Oh. Am I mute again?
Nope, you're good.
Okay, my new laptop keeps going black. So I apologize. I keep rattling cords, but I apologize. It's brand new. I have checked with a lot of people, and we had the electronic
No, you're good.
Electronic Wills Act since 2021, but nobody's really using it. And I think I think there were a lot of concerns in the beginning until we added, which is unique to Washington, the custodian provision of the electronic will. And I did find one person in King County who is acting. He owns a trust company, and he will be a custodian of electronic wills. Haven't been able to ask him if he's had any, but no one seems to be willing to do this work. I think it's a combination of it's new, nobody else is doing it, perhaps malpractice issues. All the attorneys I spoke to are still concerned about undue influence of vulnerable adults. And so, when I talked to my clerk, it's pretty clear the clerks in Washington State don't even have procedures. So I think if the first one that comes in, they're probably going to have to go through the Lost Will Act, Lost Will procedure anyway, because nobody's going to know how to do it otherwise, which of course defeats the purpose of making this simple and easy. And I don't know what else to say. I was very shocked to find that nobody was actually doing this.
After 4 years. Judge Kiesel, what's the lost will process in Washington, just for our work group members?
Well, it's just basically you have to then get the declarations from the witnesses and try to find the notary to admit a copy as a lost will.
Okay.
So again, that's kind of defeating the purpose of the electronic will statute. And I don't know if you know that Washington also enacted in June 2024 the Non-Testamentary Estate Planning Act, and I can't find anyone who's using that either. So I think I'm a limited resource as to how this works.
Yeah. Well, sometimes no information is information. So thanks for that. Susan or Ben, let me go to either one of you next. So we don't have an instructive record of the use of the act out of Washington as we hope we might, because especially the nexus between Portland and Clark County, where there's a lot of crossover between lawyers who do estate planning in both states. Thought we might see some, but we didn't find any. But you know, on these.
Excuse
Oh,
me, I
yeah,
do
Jess,
want
go
to,
ahead.
I want to clarify, I'm from Pierce County.
Oh, Pierce County, I'm sorry.
Pierce County.
That's
And the
Tacoma.
reason I'm involved is because I am the chair of the Superior Court Judges Probate Guardianship Committee. So I was the logical person to be part of this, and I'm
Okay,
pleased
thanks.
to do it.
Yeah, I apologize for that. Yeah, Pierce County, for those of you who don't know, is Tacoma. We do know that King County has set up, is in the process of setting up a registry or a custodian bank up there, but I guess that's not in place yet. Okay, so concerns, I guess, both from the questions that were presented and also just what Judge Kiesel has expressed, I guess, from practitioners that she's talked to. Susan and Ben, and for that matter too, Victoria, these were conversations you said you had in the drafting committee. Susan, maybe do you want to give us a sense of the response? And I guess I would say, I'm sorry, before you go on, just for the members of the work group, this was kind of a blue ribbon group, the drafting committee in this act, just to add a little bit of credibility to it. Attorney Berry was the chair. For those of you who go to the the Northwest Estate Planning Council big meeting every January or February up in Portland. Attorney is a regular on that circuit. Co-chair of the drafting committee was Susie Walsh, another heavy hitter member of ACTEC from Connecticut. So these are folks who are deeply involved and engaged in probate and estate planning issues, and so I'm assuming deeply sensitive to the issues that have been raised here in the conversation and questions. So Susan, maybe start with you and ask you to kind of respond or tell us how the committee worked its way through these things.
Yeah, and before I talk about security, which I think was a big concern for that group and is for you, just with respect to the Washington statute and the qualified custodian, a couple of other pieces of information. One is that there are, I think, 3 and maybe more than that. There are other states that have a qualified custodian requirement. Those states allow a business to be a qualified custodian. And the interesting thing to me about the Washington statute is that the only business that's allowed to be a custodian is a trust company. So the other states allow, and the thought was, I think, that there are businesses who offer these services. They will, you can sign up and do the electronic will. They will provide the remote notarization, and then also for a fee, provide storage of the will as a qualified custodian. So I reached out to a friend of mine in Arizona. He was also on the eWills drafting committee. And Arizona is a state that has that qualified custodian requirement. So I asked him if people were, after I heard Judge Kiesel's or saw the email saying, yeah, it's not really happening in Washington. Arizona has had the statute a couple of years longer. He's not aware of it being used there either. And he has, not used it himself, but he's also asked, he says every time he goes to a CLE there, he asks everybody. He has not heard of it being used, and he thinks it's the qualified custodian adds that additional layer, and it's probably what is keeping people from using it there. Anyway, just a little more information.
Yeah.
With respect to the security, that was a big issue for us, as I said. I pulled up, as I was thinking about some things to talk about today, pulled up the comments to the eWills Act. And I thought I'd mention a couple of those because it kind of frames just general discussion of the questions that were raised. The comments explain that the Act was seeking 3 things. And one was to allow a testator to execute a will electronically while maintaining the safeguards Will's law provides for wills executed on something tangible, which is usually paper. That was like the first concern. So that was a big issue for us. The second goal was to create execution requirements that, if followed, would result in a valid will without a court hearing, leaving harmless error aside for the moment. And the third was, and this relates to the qualified custodian issue, was to develop a process that would not enshrine a particular business model in the statutes. There were statutes being developed before we created our version by companies that were looking at this as a business development plan. They created the statutes, they were pushing them out, and the Uniform Law Commission got involved to say, no, we need to step back a minute and think about that. So we did talk about a qualified custodian in the drafting committee. We ended up not including that because we were concerned about how it would work, and we didn't think it was necessary in order to have the security that we thought was important. So comments about security specifically. I started out, I'm not a tech person. I can basically, barely use Word and email. So I started out with concerns about how this would work. I ended up believing, and part of this was kind of being shown, not just being told, but being shown that an electronic document is more secure than a paper document. It's not that we don't have the possibility of undue influence with paper documents. It's not that we don't have paper documents with pages inserted in the middle that weren't there originally. All of that kind of stuff happens with paper documents, and electronic documents are actually more secure because of the metadata, and particularly if remote notarization is used, the documents are locked. Now, it's possible technology evolves that somebody will figure out how to unlock the documents. That could happen, but it's more difficult than unstapling a will and inserting a piece of paper. So part of what we were, what helped us kind of think about that is we actually had a demonstration by one of the companies that offers remote online notarization, showing us all the steps that were taken in order to protect the document. I want to talk about those steps in a minute, but we had an actual demonstration, which is always the best way to learn something, is to see, oh yeah, it's actually, they're not just telling us it's secure, they're actually all these steps. So that was really helpful as we thought about it. What we ended up deciding to do, though, is to separate the execution of the document, what's a valid document, from the being able to admit the document to court as validly executed. So the self-proving affidavit part of it, and to keep those two separate. Because remote online notarization is so secure, we talked about requiring that for an electronic will, just making that part of the requirement. We ended up not doing that because part of what we were aware of, and it wasn't in the comments that I was referring to, but this was kind of an overriding concern, is our expectation that people would be using electronic wills who are lay people, not working with lawyers, trying to get their will done, and we wanted to give effect to a will if the person writing the will really intended that to be that person's will. And for those lay people, they assume that they can sign documents electronically because we do that. I signed a financial document yesterday electronically. We do that all the time. About the only thing where that's not permitted is a will. And so lay people don't know that they can't do it. And so they think they can. And so we were trying to balance allowing people to do that with making sure that there was enough security. So the will is valid with the testator's signature and the two witnesses' signatures, which are electronic signatures on an electronic document. In the Uniform Act, there is also a provision for a notary in place of the two witnesses. That's because in the Uniform Probate Code, that is permitted for a paper will, the notary instead of two witnesses. In Oregon, we decided not to do that. We decided not to have that provision permitting the validity with notarization instead of witnesses because we adopted the harmless error rule. And the idea was, well, if there's a notary, not two witnesses, the will can be admitted using harmless error. So one thing your committee could think about is allowing notarization to be enough instead of having the two witnesses, particularly because if it's remote online notarization, it's quite secure. I would particularly think you might want to do that if you decide not to allow harmless error for electronic wills, but I want to talk about that a little bit later. Back to the security. So we have the will itself that can be admitted to probate, but it has to be proved. And with our paper wills, at least those done by lawyers, we have self-proving affidavits that provide proof that the will was executed properly. So that's where the security piece comes in, I think, particularly effectively. So with the will itself, it's electronic. There is metadata associated with the will, so you can see the date and you can see whether there has been manipulation with the will. Has the document been altered at different times? But if there is no self-proving affidavit, the witnesses would have to provide affidavits that were acceptable to the court to prove the will. So the way we did the self-proving affidavit piece is that if the witnesses and the testator are all in the same location when the electronic will is signed, then regular electronic notarization is acceptable. That still provides a layer of protection to the will because it's logically associated with the will, and the date on that notarization also confirms the date of the will. One of the questions had to do with, and I think related to what we do with paper wills. With paper wills, testator can sign it on day one, a witness on day two, another witness on day three. It doesn't all have to happen at the same time. For an electronic will, it has to happen at the same time because the will shows the date and the notarization on the affidavit is associated with the will, and those dates have to match. So that's another layer of protection. If somebody is remote, if one of the witnesses is not in the room with the testator, then the self-proving affidavit has to be done using remote online notarization. And Oregon has adopted that statute. And that statute requires there are a whole number of different ways that identity of the person who is remote has to be proved to the notary. The notary first has to go through some additional training and get certified through the Secretary of State's office. It's a separate process to be a remote notary. Then the notary has to have satisfactory evidence of the identity of the remote person. The notary has to be able to reasonably confirm that the document in front of the notary is the same as the one in front of the remote person. The notary then records the entire process of the signing and the notarization using an audio-visual recording that has to be maintained for 10 years. So again, it's a more expensive process, the remote notarization, because the remote notary has to keep that for 10 years. And then that process associates the notarization with the electronic will in a tamper-evident file format. So it's logged in. If somebody tries to tamper with it, that would show up. And those are the kinds of protocols that are used today, again, for financial instruments, all sorts of highly sensitive things to protect them. So that provides actually a very significant amount of protection. Let's see. So that's a lot about security. While I have the floor, I'll say a word about harmless error because I already started talking about that. So I know you're debating whether to include that or not. Again, the drafting committee's goal was to give effect to a document if the person who wrote the document intended the document to be a will. There's a famous case in Michigan that where a young man wrote a note explaining that he was going to take his own life. In the note, explained that his will was on his iPhone, provided the password for the iPhone, and left those two things next to him when he did take his own life. The court applied harmless error to meet and found that all of that evidence, the situation, there were no witnesses, that was intentional on his part, that it met the clear and convincing evidence standard. So it's not that a document on a typed will on a laptop would necessarily be probated as somebody's will. There would have to be enough evidence for a court to determine that it met a clear and convincing evidence standard. If the laptop or the phone were only in the possession of the decedent and it said will, that might be enough, but under other circumstances, it might not. So that's the kind of thing that we were concerned about. And I already mentioned, I'm just looking at my notes, sorry, but I mentioned the qualified custodian issue. We had talked about that. We actually also talked about whether to have a, Attorney Barry called it a blesser. The person blessing the proceeding, having an additional person in the room, not the notary, but somebody saying, yes, everything is done according to plan. I was going back through my notes of meetings. It just, we couldn't figure out how to make that work in any way that was reasonable at all. And we concluded that the provisions that we did have were sufficient.
Great. That's outstanding. Thank you. And Susan, my recollection is that our harmless error statute, if we use harmless error, that is a formal probate. You have to give notice to the heirs before an order is entered, a judgment is entered, admitting the will and appointing the personal representative. So, something?
No, I was just going to say, and Oregon added, not only does the judge have to find that there's clear and convincing evidence that the decedent intended the document to be a will, the judge has to record that in the order, which is, we added a little extra in Oregon.
All right. Thank you, Susan. Victoria.
Yeah, I just wanted to add that as a fiduciary litigator, I'm highly skeptical, and I think that undue influence and elder abuse is everywhere. So the whole topic did not make me feel comfortable at all, but I will second what Professor Gary said about the level of security that these online notary companies use is pretty remarkable. And I wonder if that honestly is why it's not being used, because I think after the age of 32, I mean, the questions they use, they mine online and like, okay, what was your address 25 years ago? I'm not going to remember that. So I think like you get to a certain age, it strikes me as like, is the security so tight that you're going to get to a certain age and you just don't have comfort with the whole process, because it feels a little daunting. So I think and that's going to change with time, right? People get more and more comfortable with technology. And that's really what this act is about, is trying to get ahead of the demand that maybe everybody in this room doesn't have that demand, but the consumers coming behind us really do want this kind of access.
And Victoria, that provision, the security on the notary, and that's really part of Rulona, right? And not part of the E-Wills Act. That's yeah. Thanks.
If I can explain, we talked about putting it into the act and decided to just refer to Rulona in states that have it, which Oregon does, because it's all there already.
Ben, your hand is up. I was going to call on you anyway. And you look at this in other states that have adopted besides Washington. I'd be curious on your perspective, about your perspective on this conversation so far.
Sure. So just a couple of things I want to add to what Susan and Victoria have already pointed out. First, I want to caution us about reaching a conclusion that nobody is executing an electronic will because we haven't had any of them probated yet. It's also possible that the people who are executing them tend to be younger and just haven't died yet. And we don't have that information about who's executing them. There are certainly some national companies advertising. I see it on my television, and maybe you have too. Trustedwills.com is one of them. There was another company called Willing that I don't know if they're still active or not. There was a couple of the major life insurance companies were experimenting with offering this electronic wills as a service. So I do think they're out there, and some people may be using them. It's obviously we don't know. We don't collect that data until it hits the probate court. So just be cautious about saying that nobody's using these things
Good
yet.
point.
We may not know about it yet. The other thing I wanted to just add a little bit of color to the idea of having a custodian. As Susan said, some of these first generation will statutes, I think in Arizona and Nevada in particular, they required what's called a qualified custodian. And the reason they required that, I hope this doesn't sound too cynical, but the companies that wanted to serve as custodian were the ones who were drafting the bills, right? And so this is part of their business model, and they can charge an annual fee to hold your will for you. And what the drafting committee decided was not that custodianship of an electronic will is a bad idea, but that it wasn't necessary for it to be uniform because states address this issue in different ways. So in some states, the court system itself has a will registry for paper wills, or either at the county level or at the state level. And if courts want to do that for electronic wills, it's probably in the long run easier to store an electronic will than it is a paper will, and certainly states can implement those systems if they want to do that. Many well-advised people who execute an estate plan with the help of their attorney, they'll also have their attorney serve as custodian of an original copy of the signed will in case something happens, their house burns down or nobody knows where to find it, they lose the safety deposit box. The attorney can be a backup and have that. Well, there's no reason why if you work with an attorney, why your attorney can't also keep a copy of your electronic will. One of the questions talked about what it means to be an original version of the electronic will, and that term original is kind of meaningless in this context. What we want to make sure is that it's an authentic copy, and there can be multiple authentic copies that are secure and executed with an electronic signature and notarized and locked. And you can have a copy of that with your attorney's office, and you can hold a copy yourself, and you can give a copy to a trusted friend, or, there can be multiple copies, but not one of them is not the original like you would have in a wet ink signature type of world. So just adding a few things there. With respect to the Washington custodian rule, when I was working with the Washington bar, they had added this provision. They decided that this was an additional measure of security and might be a good thing. And as I said, if you want to have some sort of custodianship process for electronic wills, that's fine. I'm not sure I would use the Washington version as a model. And so with respect to Judge Kiesel and the committee that came up with it, my issue with it is that they took the criteria for serving as a will custodian. They borrowed the same criteria as who can serve as a trustee in Washington. And one of those is any individual over the age of 18. So I don't know how likely this is, but at least if you read the Washington law literally, you at least have the possibility of an 18-year-old who decides to go into business as a will custodian and says, I have some extra room on my hard drive. There's no reason why I shouldn't earn a few extra bucks, and holds themselves out as a will custodian and takes copies of people's wills and they think they're secure. And charges them a fee for it. And then, what happens if they are not backing up their records, or they lose interest in this and start a new business 5 years down the road? Or, I don't think the way that the Washington bill is written is ideal because it doesn't foreclose that possibility. If you have a responsible trust company that's serving as will custodian, that's one thing. If you have a court system that's doing it, that's one thing. If you have a licensed attorney that's serving as your custodian, that's one thing. I don't think that opening it up to any adult over 18 is a good idea. And I'll end there. And
Thanks, Ben.
sure.
And I know that you track the Uniform Acts in the states where they've been adopted. Have you seen any litigation since this act was promulgated in 2019 and first adopted after that? And again, you made a great point that there's a run up to this. People make the will and then they have to die in order for the will to be probated. And though that's when we start to see some things, but you know, has there been any litigation that you're aware of particularly on the Electronic Wills Act?
No, there has been no litigation we're aware of to interpret the Uniform Act or any of the other non-uniform acts that predated the Uniform Act that I know of. The cases that we've seen are the ones the drafting committee considered. You know, somebody does a will on their iPad. You know, can this qualify or you know, those are the only cases that I'm aware of.
Okay, just wanted to make sure that we weren't missing something out there in the landscape. All right. Before I open it up to the group to ask some further questions, I just ask Judge Kiesel or Professor Gary, Victoria, anything you want to chime in on sort of as final comments at this stage in the conversation before we open it up for questions more broadly among the group. Okay.
I'd like to make a comment. I agree that, you know, younger people are probably using this statute and it's probably through other formats like LegalZoom or whatever. And that's why it just hasn't hit the clerk's office and the court yet. But I think all of us that have these statutes better start paying attention and get a process ready to go. Because at some point, I think this is being used and it will be something that is the future, the way wills are done.
All right, thank you for that. Questions then from the group for our guests.
Lane, there are a couple questions in the chat.
Oh, okay, I'm missing those. Please, do you want to take those, Amy?
Sure. The first one is from Heather. Heather, do you want to, I can just read it or do you want to talk about it?
I think the question was answered
Okay.
in the course, and then Judge Kiesel also replied to it. It's, you know, we don't know yet whether they're being used because the character of, not the character in terms of personal character, but age and computer sophistication. And Judge Diesel's comment about, you know, people are going to be doing this. It's well taken. The problem is that there's a lot of focus on the, you know, can we notarize them? And notarization, if you remember, just verifies identity. There's no component of notarization. In theory, the notaries aren't supposed to notarize when people are incapacitated, but it's pretty hard to tell on a computer screen whether somebody has capacity or not. I mean, I think that's probably my biggest concern. My mom, she could perform great when I would FaceTime with her, but like when you really talk to her, she couldn't manage. She couldn't tell you. So I guess that's my ongoing concern about this process.
Judge Kiesel, your hand is up.
I'm on the Washington State Disability Justice Task Force. We just spent 2 years talking about access to the courts and, you know, access totally to the law for persons with disabilities. I do think that the electronic wills in many, many circumstances could help persons with disabilities. And so I hope we all every state would have at least some version for those that perhaps could benefit based on a disability where they can't just get to a lawyer.
Thanks, Judge. And disability, I think, too, probably proximity to lawyers and notaries as well. We have that, I know, in Oregon and Washington as well, where you've got some pretty remote communities and people who live pretty remote, even from remote communities, who need these services and have a tough time getting into to a lawyer's office. Heather, maybe in response to yours, I guess, do you think it's qualitatively or quantitatively different in the electronic wills arena? I mean, we've got lawyers those of us who like to think we are taking good care. We have a kind of a list of questions we ask in front of the witnesses to make sure that they actually have the opportunity to see the testator, the clarity of their thinking and their ability to understand what they're doing. That's not always the case, even in the paper wills world, that you have that kind of deep inquiry by witnesses into the state of mind of a testator. So, is that really so different in the electronic wills world than it is in the paper wills world?
If you're asking me directly, my 35 years of experience of doing that is, yeah, it is different. That's my personal experience. Some of this and a lot of the marketing that's related to it reminds me of, who's old enough to remember universal living trusts that were sold by insurance and financial guys, and a lawyer was tacitly involved. And when I say tacitly, I mean that in the loosest sense. That it's kind of reminiscent of that for me, but I still have an open mind because I agree with Judge Kiesel's comment. It's coming. What are we going to do?
Judge Kiesel, I saw your hand up and then I lost you on my screen. Are you with? Oh, there you are. Did you want to get in on this again? If you are, you're muted. Or maybe not. All right. Oh.
Yeah, my computer keeps blacking out. I'm sorry. Now you can't see me. But the one thing that I thought that maybe we should have added that we didn't add was, since this is all electronic, why don't we have a component where you can do this by like Zoom or some other platform, record the testator's signing? And frankly, as a lawyer, I did that quite often when I knew I'd be faced with a will contest down the road. So I guess that's the one thing I think could really help the courts when we get to probating these wills.
All right, let me ask Professor Gary, Susan, Ben, Victoria, did that come up in the work group, the drafting committee, and how did you end up? How did you resolve it the way you resolved it?
Well, it was resolved by putting that into the self-proving affidavit.
Okay.
So it's not required for the execution itself. It is required if anyone is remote, and then Rolona applies, and exactly, I think for that reason, that's better evidence, because there is that recording that will then be available.
Yeah, and I'll just add, the drafting committee was trying not to duplicate in this act what already exists in the notarization law. And so for a state like Oregon or Washington that already has the requirement for an electronic notarization that it be recorded on video and audio and maintained for 10 years, that's part of the law already. It's required if you're going to have a self-proving will. And of course, everybody should have a self-proving will. The only reason the provision is in there for otherwise, for to have a will that's not self-proving, is to cover the case of those do-it-yourselfers, because it's better than the alternative that you at least have a clear and convincing evidence standard that you could admit the will, than completely throw away a person's plan of distribution because they didn't understand some of the formalities that they needed to do.
And Heather, your comment in the chat, notary requirements only apply to the witnesses as to identity. I guess Ben and Susan is thinking that that recording would still pick up, would still demonstrate the testator's capacity as well in the process of execution.
I think that's the idea, and it would depend, as Heather said, or maybe actually Lane, you were saying some lawyers would ask some questions to establish capacity in front of the witnesses. The lawyer could do that in any event, but a lot of lawyers probably don't do that. And there isn't anything required as part of the process. But the recording would record whatever was going on, so it would provide some information.
All right. Anybody else? Jeff, how about you?
Wayne Matthews had his hand up for a while.
Oh,
Yeah,
I'm sorry.
Matt's got his
Who am I
hand up.
missing? Oh, okay, Matt, I was going to get to you as well. Sorry, the hand is kind of hidden by your seal there on, but I see it. Let's go with Matt, and then Jeff, I'll come back to you.
Ben's last comment might have partially addressed my question. So when Susan was describing security, a lot of the description surrounds the remote notarization. My concern was if they opt not to use a notary and just use witnesses. And then I guess Ben's point is until those witnesses also sign their affidavits, the will is not self-proving. And in order for them to sign the affidavits, they would need to use a notary and presumably use the remote notarization procedures, which then kind of bootstraps in the level of security that the notary process provides. Is that?
Yeah, that's exactly right. Exactly right, Matthew. If it's a non-self-proving will where it's just signed and witnessed without a notary present, without any affidavits, then you have to go through the whole same process that you do with a paper will in order to admit it. If it's a non-self-proving will, you have to interview the witnesses in court. You have to, say, were you there? Do you remember this? Did the person have capacity as far as you could tell? Was it, it's a lot. It should be a lot more difficult. There's a higher bar to get that will admitted when it's non-self-proving than a will that is self-proving.
And if I can just, Matt, on your question about when the sequence, I guess, in which the witnesses sign affidavits, the Uniform Act requires a self-proving will that the affidavit be done contemporaneously with the will, so that we have a record that the witnesses are actually witnessing that will. So it wouldn't be a matter of getting of having the witnesses witness and then a witness execute an affidavit the next day and another witness execute an affidavit a week later. That wouldn't be a self-proving will under the Uniform Act, right? Yeah, so the whole thing has to occur in a contemporaneous manner in order to both the execution and the witnessing of the affidavit in order to make it a self-proving will.
And where in the act is it that it's requiring that to be simultaneous?
Is that in Section 5, or is it?
The affidavit is Section 8, of the Uniform Act.
Yeah, it is Section 8. Yeah, Matt, it's the first sentence of Section 8. An electronic will may be simultaneously executed, attested, and made self-proving. And yeah, again, that follows through with the execution of the affidavit being at the same time as the execution of the will.
I guess I read that language potentially differently.
Okay, well, we want to clarify that then, because
it says maybe.
Yeah.
Doesn't say that the only way to make it self-proving is by simultaneous affidavits.
So if we were to add some clarifying language, that would not be a non-uniform modification of the act, if you think that needs to be clarified, because that certainly is the intent.
Correct.
Anything else, Matt? Your hand was still up.
Partly because I don't often use Zoom, but I do have a different question or comment. One of my concerns, I guess, was if proving the will or disproving the will comes down to metadata, that's a very nuanced, complicated tech issue that I'm not familiar with. I doubt anybody in my office is familiar with. I doubt many judges are familiar with, and seems I am skeptical. I'm concerned about the potential for fraud, and if the burdens of disproving a fraudulent will are onerous in just a practical manner of needing an expert witness who can parse through metadata, I have pretty significant concerns about that.
Okay, I'm ignorant on this too. Is metadata hard to make your way through? Anybody know?
I'm just guessing it wouldn't be more difficult to get an expert to do that than it would be to hire a handwriting expert if there's a concern about a paper will based on handwriting or something like that. I think. I mean, I think the people who do that it's pretty easy to do. I'm like you, Matt. Not my thing, but there are people who know how to do that.
Yeah,
And that's
I
a good-
think that there's a lot of experts that do that if you're trying to prove that a document was created on a different date than what it says on it. So yeah, there's a bunch of nerds that can go in and readily figure that out.
Okay. And you know, just as we have these questions, I get, this is in your response too. These are issues with paper wills as well. These aren't just unique to electronic wills. So it's we're not yeah, these all exist in that in our tangible world as well as the intangible. Lorianne, your hand is up, but I think I said I would go to Jeff next. If you've got anything you want to add, Jeff, and then we'll go to Lorianne.
I'll defer to Lorianne first.
Okay. Lorianne first, what's the hand report?
Hi. It's doing well. Thanks.
Good. Okay.
I had a question about somebody had said that in order for the electronic will to be self-proving, has to be part of the same recording as the notarization. But I'm not seeing anything in here that requires for the notarization to be electronic. Could it not be witnessed in person and notarized in person? Or is there a requirement that it has to be electronically notarized?
I'll defer to Susan if you want, but I think it gets a bit difficult. In theory, you could have an electronic will in the sense that it is a secure PDF document, right? And you could bring that into a notary's office, and the notary would have to load it on their computer, and maybe with a pen and a signature pad, have you sign there, and then use the electronic, or use the procedure to use the notary's own secure software to add their stamp and seal and secure that document. That ends up being, I think, essentially an electronic notarization, as if you had done it online. In other words, the notary doesn't have different technology for somebody who walks into their office with a document as they do for somebody who accesses them through Zoom online. The software that adds the notary's seal and makes the document secure and tamper evident is the same whether the person signing it is there in person or is remote. And I hope I got that correct. Susan, please correct me if your understanding is different.
And I think I was checking the statute as you were talking, so I may have missed this, but I think you were saying that the notary would still have to do the notarization on the computer. Because the statute requires, the place where it's required, it uses the term logically associated. So it says it has to be evidenced by the officer's certificate under official seal affixed to or logically associated with the electronic will. And so if the will is electronic, the only way to affix the seal is through this, it's called logically associated. We considered adding a definition of logically associated in the act, and we didn't do that. It's not defined in some of the other uniform acts that use that term. It's a term related to the technology, and our concern with trying to define it was that we might define it too narrowly. Relates to another concern we had. We didn't want to require a particular platform, a particular type of technology. Technology is changing so rapidly that we were worried that we would lock something in that would be out of date in a year or two. And so logically associated, as I understand it, is that those two electronic documents are linked in a way that is connected and tamper resistant. So you could, if somebody tried to disassociate them, you could tell. I think that's right.
Yeah, and what I'll just add to that. So we're not writing on a blank slate, right? We're building on none of this technology is new. It's used for electronic contracts. It has been since the Uniform Electronic Transactions Act of 1999, which has been adopted in every state. And that's where this language comes from of what it means to sign, that it can be logically associated or affixed. That's where that definition comes from. So it's law in Oregon and every other state. And it is the same language also used in the Notarization Act.
Okay. Jeff, we're almost out of time, but I want to come back to you since you deferred to Lorianne for your comments, questions.
I know we're almost out of time, and I probably have way more questions after hearing everything today. But I will sort of maybe just touch on when Ben was talking about there not being an electronic original, which, like, I can understand that there are functional copies of the same electronic will in this circumstance. At least Oregon statutes are very focused on what an original will looks like, and that's probably a broader consideration if we're talking about electronic wills as a substitute for what otherwise would be the probated document. And again, if people are doing this and they haven't died yet, I'm glad they're living. But at least from the court's point of view, that's really what we're focused on, is like the process when they die, which could be tomorrow or it could be in 20 years. So some of this discussion that Judge Kiesel is talking about, having to come up with a process, I mean, that's really, at least my perspective and the people I'm working with, the judges and court staff, kind of a big concern with any big change. So at least to provide some context for the questions, I think got circulated that I had sent in.
Yeah, okay. It would be a matter of figuring out a way to accept an electronic filing.
And I'm still not totally sold on the transition from whatever proprietary technology is being used for this into something the court can receive or acknowledge, or, you know, that we still very much live in a case file world where there's a custodian at the court. It's electronic, but there's an original case file. And I don't know how these two ideas synthesize there, at least.
Okay. That might be a good question for IT inside the judicial department. It is a good question. And Ben, Susan, I know we have a provision in the act that a certified copy may be made. It is a hard copy may be made of an electronic will. And I suppose one thing would be to, you can say that needs to be done and filed, and that becomes the document, Jeff. So you actually have a document submitted that way. I don't know. don't plan to resolve it. I want to be in this meeting. We're out of time, but something to think about. Either that, or else the courts devise a process for accepting this electronic filing and acknowledging that as the original will for the purpose of probate. That's going to require a different mindset, I think, how to approach this. But we are out of time. I want to be respectful of folks' hour. Really great conversation. Judge Kiesel, Professor Gary, Ben, thanks for being with us today. We will, Amy is taking good notes, I know, of this conversation. We will follow up with this. And Amy, we have another meeting in a month, right?
That's correct.
Yeah, folks, we're taking a nice leisurely pace here because we're not planning on introducing this in 2026. So don't fret, it'll probably get more frenetic as we get closer to an actual drop dead date. But for now, we can just kind of take it slow. Yeah, so we will see you all in November. If you have more questions, send them on in to Amy. That worked out really well. And we'll see if we can get some more answers ahead of the next meeting, or at the next meeting if that becomes something it looks like we need to do. All right, thanks everybody. Have a great Friday and a great weekend, and enjoy these last couple sunny days. Looks like it's going to be rainy here for a while come next week. So thanks again, everyone.